Good morning. May it please the court. Margaret Goodernest and Cherry Grant on behalf of appellant John Goodman, who appeals his conviction for DUI manslaughter with an enhancement for failure to render aid. I request to save 10 minutes for rebuttal, please. I'm going to address issues 1, 4, 2, and a mention of 6 and 12. The first issue is the Trombetta issue, which concerns the special significance of the state's obligation and duty to preserve evidence that is materially exculpatory to the defense, which Trombetta describes as that which might be expected to play a significant role in the suspect's defense. There's 2 prongs to this test, and those prongs are: before the evidence is destroyed, does it possess an exculpatory value that is apparent? And 2, is it of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means? In this case, the physical car, the Bentley, was very, very important to the defense. And that was apparent before it was destroyed when you look at how the physical car was utilized by the defense in the first trial in this case.
Well, isn't that the point? They already examined it, and they got the information that they needed that would have been exculpatory to them.
But they also presented that car to the jury. And that's not the test.
Well, they had pictures.
That's not the test under Trombetta. There are only 2 Trombetta reversals that I have found. And in both of these cases, the defendant examines the evidence. They find something exculpatory helpful to the defense from the evidence. I'm thinking specifically now of the Georgia Blackwell case, which is the urine test case. The first test was negative. Then the state tested it, and it was positive for drugs. It doesn't lose its exculpatory value to the defense once that value is established.
The defense never got to test it in Blackwell.
The defense did test it. The first test done was negative for drugs.
That was the defense's test?
Yeah, well, it was a test by his probation officer.
Okay. Well,
and it was a negative test, and it was of value. But the state keeps trying to add different requirements to the Trombetta test here. And the test is, was it helpful to the defendant? Was it apparent to the state that this was helpful to the defense at the time it was destroyed? And that is very clear on this record. At the motion to dismiss hearing, Investigator Snellgrove testified that he was aware that the Bentley was a significant piece of evidence for the defendant before it was destroyed. That's at electronic transcript 6333. And even the prosecutor Roberts in her testimony admitted that Sadar said if the throttle plate was not able to close because it was stuck, it would be more difficult to stop the Bentley using the brakes. And this malfunction of the throttle, it was a condition, an unsafe condition where the 2 throttle banks were imbalanced and out of sync, and it could possibly create a drivability problem. And Mr.
Did Sadar testify at some point that he didn't need to do any more testing?
He testified to that in his deposition before the first trial, which was before the state came up with the expert from the manufacturer of Bentley, from Volkswagen Group. They reached out once they realized that they were not prepared to meet Sadar's testimony in this first trial. And they get an expert to come from Bentley's sudden acceleration expert, who comes and looks at the Bentley, and as they're pressing the prosecutor, what's the opinion? What is this expert going to testify to? Prosecutor Collins says right there in court, she says, he doesn't have an opinion. He has to see until he sees the Bentley. It was physically important to see the physical Bentley before he could come up with a test. And it's not what else the defendant should have done, or he should have run more tests, or why didn't he do this. The test is, did it possess an actual apparent exculpatory value to the defendant at the time it was destroyed? And the court below did not address that test. He kept looking at, well, from the point that the second trial began, when the defendant asked to see the car, the defendant wanted to do other things, and we don't know what those tests would have shown. So they're starting to ask that it be a young blood evaluation. It's not a young blood, it's a Trombetta.
But the second part of Trombetta talks about and they'd be unable, the defendant be unable to obtain comparable evidence. And then exactly in Trombetta, they said with the breath samples, which were destroyed, they said the chances, Justice Thurgood Marshall said, it was extremely low that the defendant would get anything exculpatory. Isn't that the same thing here? You had the first trial, you had the expert, they looked at it, they had exculpatory evidence, and then, so it's not like the destruction leaves you without any evidence. You do have, and the ability to have additional evidence that's exculpatory seems to be also extremely low.
Well, but in this case, there was a second reason why the Bentley was so important, the physical car, and that is that there was a jury view in the first trial. And both of the parties in the testimony talk about the physical condition of the Bentley as displayed to the jury, that it was very important to determine the circumstances of the accident, which bore on the essential question also present in the second issue on appeal, as to whether the defendant actually knew that the accident resulted in someone being in the car in the canal, to prove that the state had to prove the defendant had knowledge. And in this accident, the defendant was injured. He had a broken wrist, he had a broken sternum, he hit his head on the left side, the airbags went off, the defendant testified, and the first witnesses on the scene testified they didn't see another car. They thought this was a hit and run. And the experts, Investigator Snellgrove for the state and Michael Urban for the defense, differed on how the accident occurred. Snellgrove said that when the T-bone accident occurred, that the Hyundai went up on the hood of the Bentley, and that somehow it turned the corner and the rear end of the Hyundai caused the damage to the driver's side window. And then, this is very important to the knowledge element, and then Snellgrove said that the Bentley pushed the Hyundai into the canal, and that from the point of collision to the point it went into the canal was 6 seconds. Michael Urban testified that, as in any accident, when you have when there was a force, that the Hyundai rotated away, and there was a secondary impact on the driver's side of the car, which broke the mirror, and you can see the damage better from the Bentley itself. And if the Hyundai had gone up onto the hood of the car, there would have been more damage to the hood. And then he says it rotated back away and fell into the canal. And Urban's testimony is from the point of collision to the point of the Hyundai going into the canal was 3 seconds. So at the first trial, under examination from the state, Investigator Rieger says to the prosecutor, you can see this damage to the driver's window better on the Bentley than in the pictures. And Urban also said that the side slap damage to the Bentley is most evident on the Bentley itself. So this was a case where they brought in the car because physically they had to examine this car to determine the circumstances, and also the Hyundai they brought in. And we are contending that the testimony of Urban, the car itself, the testimony about the ECMs, and once Livernois came down, the defendant never got to...
As how the car and how the accident occurred, how is that exculpatory, showing this? It shows how the accident occurred. But
it also supports the defendant's defense, and this test is not that the defendant has to show that it is so exculpatory he's entitled to a judgment of acquittal. That is not what Trombetta says. It's exculpatory because if the circumstances of the accident were so quick and so sudden, and if it's the Hyundai spinning that puts it in the canal, then it's entirely plausible that the defendant's testimony is supported that he didn't know what happened to the other car. It disappeared suddenly. He was unconscious for a short period of time from his head injury.
So that would go to the enhancement.
That goes to whether the state has proved whether or not the defendant had knowledge of the injuries and deaths.
The enhancement.
Yes.
So for the DUI manslaughter, though, it really isn't a defense, because in there, all they got to show is that his conduct somehow caused or contributed to the accident. And clearly there's plenty of evidence here, irrespective of whether or not the car was mechanically malfunctioning or whether, that he contributed. I mean, at the best, well, for instance, they showed he was speeding. So they have other evidence. So it kind of goes without saying that the DUI manslaughter, none of this would help him there.
I do believe that the malfunction of the Bentley does help him. I think it was very important, and the best evidence it is that it was important is that when the state realized they were unprepared to meet Sidar's testimony, they went out in the middle of trial, came up with a brand new expert, hired an expert.
That was for the first trial.
Yes, but
We're
you
talking
have
about the second trial.
No, you have to. I'm still talking about the Trombetta point, but I will move on here. That Trombetta, but that to look at Trombetta, you have to see at the point that the car was destroyed, had it been shown to be helpful to the defendant. And I contend that we contend that it had been at that point. The second point I want to address is actually point 4, which is the trial court's order denying the motion to suppress the forced blood draw. The judge denied this, finding there were exigent circumstances and that a forced blood draw is authorized by the implied consent statute under 316.1933. Now, the exigent circumstances that the court comes up with, we contend that his findings of fact, finding exigency, cannot be based on hypothetical facts, and that is what the judge concluded here for the exigency, such as when the judge said in the order that Snellgrove estimated it would take 2.5 and 3 hours to get a warrant.
But wasn't there testimony, about all that was going on at the time at the scene, all of the... Yeah, there were quite a few officers there on the scene,
yes,
but they were having to attend to different issues. The defendant himself didn't come back to the scene of the accident until an hour later. They hadn't located the victim or the car that the victim was driving at that point. 3 hours had passed, I think, before the time that the accident occurred and the time that the blood draw was done at the hospital. So, I mean, there weren't just hypothetical facts. It seems to me that the record showed all that was going on at the time of this investigation that could have supported the trial judge's finding of exigent circumstances.
Okay, the judge's order, the first 3 paragraphs are facts, and I have no problem with those facts. Those facts are the accident occurred at 1 o'clock. Shortly after 1 o'clock, there were officers on the scene. The car in the canal is pointed out by civilians, so there's at least a possibility that someone's in the canal. Before 2 o'clock, the defendant is back on the scene. He has called, he has reported the accident. He said he was the driver. It's not a complicated investigation. He says he's the driver. The officers detect the odor of alcohol and other indications of drinking. The defendant is injured, and so he goes to the hospital. At 2:31, they pull the Hyundai from the canal, and Scott Wilson's body is discovered. So by 2:30, they have probable cause to believe they have a DUI manslaughter, and there are multiple, by 2:35, there are multiple specifically trained traffic homicide investigators on the scene. And that was the time, at 2:35, that's the time to start thinking about getting a warrant. But they don't even call Snellgrove for 40 more minutes, and then it's 10 minutes before he shows up. And there's no evidence in this record how long you have to get a blood test before it dissipates so that retrograde extrapolation is no longer valid. That, and that's one thing they mention in McNeely and in Birchfield is that, with retrograde extrapolation, the fact that it's a while after doesn't make any difference because we know how to relate back now scientifically. And, but the hypothetical facts are how long it would have taken him to get a warrant if he had tried. Why, the duty judge might live in Boca or Jupiter, and here we are in Wellington. Well, that's hypothetical. Who was the duty judge? Did he live or she live in Wellington? Palm Beach County is a big county, and we can't use technology. We can't fax. That this one sole officer has to drive the warrant about. Now, that's just foolishness. That is just not true. There is no authority.
Well, doesn't Snellgrove,
Snellgrove, yes.
he obviously, having investigated a lot of these things, he knows that he has to get a blood draw soon, right? I
He
mean,
didn't say that. He said he didn't even think about getting a warrant, and he didn't even think about exigent circumstances. All of these exigent circumstances the state puts out here are after
well, he
the
knew he had a
fact.
death, and he knew that they had the guy who probably was knew the driver that was in the hospital.
But they knew
getting
that
some
50
treatment.
minutes before Snellgroves gets on the scene. There's no explanation why other officers didn't, because other traffic homicide investigators are there. And there's no authority, the state cites no reason why they can't use technology. And the case that this defense showed evidence of, this Officer Hanlon's saturation DUI enforcement case from '09, they used facts in that case. And an hour was the amount of time that Birchfield says suggests a warrant can be obtained using technology. And we say evidence doesn't support finding of exigent circumstances the state is relying on. It's a big county. We've only got one officer to get the warrant. Why can't there be teamwork? Why aren't they working together? Why does it fall on someone they call that gets there 50 minutes after they get probable cause? Why is he the one that has to get the warrant and not the other officers on the scene? Because it wasn't that complicated. There wasn't a lot going on that these other officers had to do. This should have been a joint effort. As to the second finding of the court was implied consent. And the court relied on 316.1933. But after 2002, that statute was amended, and it does not contain any reference to implied consent. It is not an implied consent statute. The implied consent references were deleted. Now, 316.1932 is still an implied consent statute, but implied consent, a defendant can still refuse a blood test, and the only consequence is his driver's license is suspended. 316.1993, it directs a police officer who believes there's been a DUI with serious injury and the defendant's at the hospital to require the suspect to submit to a blood test. And it says the officer can use force if the defendant refuses. Well, how does an officer require someone to comply with a search when the person doesn't consent? They get a warrant. And McNeely and Birchfield both say that Schmerber has always required a warrant for a blood draw absent exigent circumstances. And this amended statute doesn't mandate anything but that the blood test be conducted in a reasonable manner. And I say whenever a statute, when you say reasonable, it brings up the reasonable, reasonableness is the touchstone of the Fourth Amendment. And when it tells the officer to do this in a reasonable manner, the officer should be thinking about a warrant and should get a warrant when its consent is withdrawn. And my argument is that the officer nor the court can rely on a statute that doesn't say what they think the statute says. When you read that statute, it is not an implied consent statute. And all of the state citations here in this court, and all of the ones that the court relied on in his order for implied consent, are pre-2002 implied consent cases. There are none that talk about this amendment and the fact that this statute doesn't say that anymore. Now, the state on appeal has asked that you apply the good faith exception. Good faith was not found by the trial court, and specifically the state asked the court not to rely on good faith. At electronic transcript 4956 and 57, she's saying don't rely on good faith. They're asking for a rule that because this county is so big and there's only one officer and we can't use technology, we always are not going to be able to get a warrant. It's always going to be exigent circumstances. And that can't fly because that is not a proper exigent circumstance finding. So the Attorney General is now asking for a finding of good faith. But under Davis, an officer needs to rely in good faith on binding appellate precedent specifically authorizing the particular police procedure. And I contend that good faith cannot apply because when McNeely and Birchfield both say that Schmerber has always required a warrant absent exigent circumstances, and there is no bright line case in Florida that exempts blood draws from exigent circumstances or the warrant requirement. There is a lot of dicta in some cases that suggests no warrant is needed. but dicta is not binding appellate precedent, and that is what is needed for good faith. So the exclusionary rule should apply here because the officers were deliberately reckless and grossly negligent in violating appellant's Fourth Amendment rights. It is not reasonable for an officer to believe that he can invade a body to extract samples without doing a Fourth Amendment analysis or a constitutional analysis and getting a warrant. And so we contend here that good faith does not apply, and that the other officers should also have been involved, and if with some teamwork. You can't just say, oh, this one officer couldn't possibly get a warrant. He had the whole sheriff's office at his disposal. You can fax something to the substation in Boca and get an original signature if that's what it takes. I'm not sure that it really does take that, because the state was their burden to show that some exception to the warrant requirement applied, and they did not show what authority might have been as to why they couldn't use technology. As to the second point on the jury instruction, this concerns whether is actual knowledge, that not constructive knowledge, that someone was injured or dead in the accident, an essential element that the state had to prove beyond a reasonable doubt to prove the failure to render aid
Can
enhancement.
I ask you a question
Yes,
as the
ma'am.
facts, because I'm somewhat confused by
Yes.
your argument here, because you say that the court erred in instructing knew or should have known.
Yes, that's what I
When
said.
I read the instructions in the record, it doesn't look to me like they instructed at all. In other words, it says you must further determine whether the state proved beyond a reasonable doubt that John Goodman at the time of the crash, A, knew that the crash had occurred, and B, willfully failed to give the information, et cetera, et cetera. In other words, there isn't any instruction on knowledge or injury or knowledge of injury or damage. They said before trial that they were going to do that.
Well, they said before trial, they asked, and they said that in light of Dumas, I did check it again because I was checking the third part of this point too, which is, and they further instructed the jury that the state did not have to prove that the defendant
On the
knew.
vehicular homicide.
Yes, but given how these two were so intertwined, it would really be hard for the jury.
Well, they didn't instruct on knew or should have known there either.
No, they didn't. They
eliminated-
said the state doesn't have to prove knowledge at all. And
They
it
said
really
that at
is
the time
very.
of the accident, John Goodman knew that an accident occurred, and two, that he willfully failed to give the information. And then they say willfully means intentionally. However, the state is not required to prove John Goodman knew that the accident resulted in the injury. So in that case, they didn't say knew or should have known at the top, and then they said they're
Oh,
not
but-
required to prove knowledge. But on
But
the
this is-
DUI manslaughter, they didn't even instruct on that.
Well, this is a enhancement of a civil infraction, 316.062, which has not yet been construed. And it's not the leaving the scene of an accident under 316.027, which is a criminal offense with a death or injury. And we contend that it should be an element, and they should have been instructed on the knowledge element, particularly when he defended on the ground that he did not have any actual knowledge, that he would never have left the scene had he known that someone was in a canal and needed aid.
Well, if we were to agree, well, the posture here is there was no instruction. They didn't instruct at all on it. So it's not a matter of whether it's knew or should have known, it's they never instructed on it.
Well, and he objected and asked for that instruction at the charge conference, and I missed that. Should have been given. And he also asked for the theory of defense instruction that the state had to prove actual knowledge, and that it's misleading about a suspect's legal obligations, because you can't require him to render aid without requiring that he have the knowledge necessary, because you
That would
can't
be
criminal.
Mancuso, right? Mancuso says you have to have some sort of.
Mancuso says that, Delva says, Mancuso,
Mancuso
I'm
says
sorry,
knew or should have
Mancuso, Dumas, and also Discord.
Yeah, but they all
endorse
say knew
that.
or should have known.
Yes, but they say knew or should have known from the circumstances of the accident, and none of that was instructed to the jury in this case. And as As for point 6, I would just say that there is an error in the brief on page 66. It's not the hydrocodone evidence that lengthy bench conference is referring to. Dr. Gingo was trying to testify to retrograde extrapolation as to the alcohol test to show that the state did not have an adequate predicate here. They didn't know when the last drink was consumed. They had other things that weren't asked to the predicate, and the court misconstrued the Dauber test as a test of relevancy and did not allow the defendant to get this testimony on. And what's relevant to show a reasonable doubt for the defendant is different than what is relevant for the state to prove its case.
Let me ask you a question on the jury instruction thing.
Yes.
Assuming that you can get by and agree that there is an error in the instructions on the enhancement, what's the remedy here?
The remedy,
The only error we find is on the enhancement.
and he was sentenced to 16 years, which he couldn't have received for the DUI. He still gets a new trial because the whole tenor of his state of mind about he left, they kept saying he left the man to drown in the canal. It's also becomes a character attack on the defendant when they put on that kind of evidence and supposition as to why he acted the way he acted. And
Isn't there, but DUI manslaughter without the enhancement would be proved, wouldn't it? There's not,
that error might only go to the enhancement, yes. Yes, and as to point 12, I'm going to say quickly, I rely on Messias in my reply brief. You have said you can't abate one conviction at sentencing, and particularly the state's suggestion that if you reverse the DUI manslaughter, that they can go back and sentence him on the vehicular homicide. And then what do? Have another appeal? That's just...
Well, yeah, but what is a court? Maybe that's why we get on post-conviction relief so many double jeopardy issues saying, well, you shouldn't have convicted them both, because they're convicting them of each one just to preserve it for the appeal, and then we'll take care of it.
I don't know the motives, I just know it's wrong.
So maybe what the state should do is convict them and sentence them on both, and then you can argue that one is a double jeopardy, and then we can throw it out, rather than
Except
abate
that what if a lawyer doesn't catch that? The case law from this court in Messias is very clear. You cannot hold it in abatement. You have to dismiss one at the time you sentence on the other. I'll try to save my remaining time.
Thanks.
May it please the court, my name is Richard Valentis and I represent the state of Florida. To answer Judge Warner's question about issue 2 to opposing counsel, I would just refer to page 39 of the initial brief, where the defendant actually says the lack of the proper element of contested proof should result in the reversal of the enhancement portion for a new trial. So they've already stated out what the remedy should be in their brief, and that would be just a new trial in the enhancement section, not an entire new trial as they're claiming now.
Well, would you want, how can you try just the enhancement? If we were to decide this were an error, wouldn't the better thing to do to say, okay, you either get a new trial on everything, or state you can just go without the enhancement?
Well, the enhancement would, I think they'd be able to prove whether the enhancement portion, well, I don't know why you couldn't bifurcate the trial on that.
They'd have to try the whole thing again with what happened to the cars and whether he knew or should have known, and maybe the level of his intoxication and stuff like that. And the whole
It might
thing
get difficult. Yeah, it might get difficult,
but wouldn't it be? Wouldn't it be easier to either just say, okay, you didn't prove the enhancement, or that you don't get that, or the state has the option of either saying we're going to have a whole new trial, or go back and do.
It may be easier, but that doesn't mean that should be the result, because it's going to be more difficult. The state is entitled to due process as well, and I would just point out, since we're discussing issue 2, and as you pointed out, Judge Warner, there was nothing in the knew or should have known for the DUI manslaughter instruction. But I'd also point out that there's nothing in the plain language of 316.193, 3C, 1, or 2, or 316.062 sub 1 that actually require that language in there. So basically, the instruction.
Doesn't Mancuso, under a similar circumstance, when they say, because the statute says fail to comply with the duties under 316. And Mancuso says, well, that you have to have, because it's an affirmative obligation, you have to have a knowledge component.
Right, but I think what changes that entire context is this is under the DUI statute. And I think that is why the statute, I think it's 316-0027, as opposed to what we have charged here in the DUI manslaughter, is different. As Your Honor pointed out earlier, what do we have to do for DUI manslaughter? We got to prove that you caused the accident, you were impaired or .08 or above, and that a death resulted. That's
Right,
what you have to prove.
But the reason why 027 is different, of course, that's why, if you ask me, I'm not sure that Dorset applies in this circumstance even to the crash, but because the statute has knew or should have known that a crash occurred as the knowledge component on the crash, but we're not arguing about that.
Right, we don't.
As to the knowledge component, though, it seems to me it's the same. It's identical as to, on the knowledge of the accident, because Mancuso was saying, well, if you have to comply with, an affirmative duty under 316.062, which they're both the same in that circumstance.
I don't believe they are the same. I thought that was the whole reason why Dorset came about, is because in the one aspect of 316.0027, I believe there was it was willfully
Oh, right.
versus knew or should have known, and there was that conflict, and he said, well, you can't have knew or should have known because that's a big conflict with willfully. We don't have that in 316.0062 at all.
But the question is, do you need you're saying we don't need an instruction at all. Whereas Mancuso would say, oh, yes, you do but it's knew or should have known on accident, the accident injury or produces injury or death.
And if that's the way the court interprets Mancuso, then what you would be doing is adding language to statutes, which is not permissible. There's nothing in the statute, either, like I said, 316.193 or 316.062, that requires that language, and that's why it's not in the standard jury instructions,
But
I would assume.
it wasn't in Mancuso either, and the court said, when you don't comply with when the direction of the statute is that you must comply with 316.062, which is an affirmative duty, that there has to be a knowledge component.
I thought Mancuso was a 027 statute.
It
not-
is,
and they're
but
not-
it's the same, what I'm saying is it's similar. It doesn't have a knowledge component in 027 any more than it has a knowledge component in 193.
I believe 027 does have that
027
knowledge
has
component.
a willful knowledge of the involved in the accident.
Right.
But it doesn't separate it out, and Mancuso then separated it out and said, first, you have to have knowledge, and which we're going to attribute to knew or should have known, because the question in Mancuso, I can't remember if
it's
Mancuso.
It's the injury, Your Honor.
The injury, right.
The injury, not the crash, and that's, I guess, why it's getting a little confusing with
Well-
Dorset was you had to have knowledge of the crash, and knowledge meaning willfully, but we also had the knew or should have known language, and that's how Dorset came about the crash. We don't
But
have
Dorset-
that in the
No, because-
context of injuries, and particularly DUI injuries. And I think looking closely at the DUI statute and what they're regulating in the DUI statutes should take it out of that.
Well, then, would you make it a strict liability crime? In other words, that if you fail to report, you're so drunk you don't report that you're out of it. You're strictly liable.
Well, they do
I mean,
have-
are you advocating for a strict liability crime on the enhancement portion of that?
Well, they still had the willful portions in there. I think you have to know of the crash, and then the willful is to render aid. You willfully failed to render aid, or willfully
Well, but
didn't
if you
give the
have to
information.
know, the only time you have to render aid is if there is an injury or death. So you could willfully leave and not give the information that you need, and you wouldn't have any idea whether there was a death or injury.
Well, Your Honor, I could just direct you to the plain language of the statute, which does not require the language that the court is discussing now.
Yeah, run that by me one minute. So what's the argument why these cases aren't, we're not compelled by them?
Well, they're different statutes, first of all, and then secondly, the context is you just have a garden variety accident. Okay, you have to stop and give information. You have to stop and render aid.
Right.
To me, the seriousness of the offense and what's going on is ratcheted up tremendously when you have someone who's under the influence of intoxicants, and in my opinion is probably a lot less likely. Are you going to be able, I think it was Dumas pointed out, are you going to be able to avoid this knew or should have known if you're going to read that into the DUI manslaughter enhancement? Are you going to say, well, I was too drunk, I couldn't know or should have known?
Dumas still required that you be instructed as to injury. It didn't, I mean, that was the difference between injury or death, I thought, in that case. So whereas.
Correct.
dissent
And those
was
were
saying-
equivalent.
right. So, but in this case, neither one, as to the injury, was instructed. So if we use Dumas as the example, why shouldn't they have at least been instructed as to injury?
Again, I would just, unless
I'm
the
just
court.
trying to get you to.
Yeah, well, I'm just trying to say that I don't know how the court can instruct on elements that don't exist in the statute
The
and that aren't
element does
charged.
exist. It says that
Okay.
the second element is that they failed to render aid in accordance with this section.
Correct.
Okay. There is, unlike knew or should have known that a crash occurred, which is the first element that they instruct on, there's a knowledge element there. There is none on that one. And under State versus Giorgetti, is that the right? I mean, and there's multiple cases that talk about the fact that where there's, let me see if I can find it in there. That where the legislature defines it, then, okay, we would note that the legislature generally has broad authority to determine any requirement for intent or knowledge in the definition of a crime. So you look to the language of the statute first. But then they say that when there isn't, then, and as a matter of fact, Dorset talks about that, when there is nothing or it's ambiguous, then the courts have to look at what kind of a crime it is and whether or not, and then quite frankly, I think it's Adkins that says that you need an intent element in all crimes unless it's a strict liability crime. And they've never allowed something as dramatic as going from a second-degree felony to a first-degree felony to go without a knowledge element of something here. And they say where there's an affirmative duty, there must be a knowledge element, that you must be knowing that you are breaching. And then, of course, Mancuso says that knowledge element is knew or should have known.
Well, I would just point out the plain language of the statute, and I do believe.
What the plain
Well,
language of the
the plain
statute
language of
says?
316.0062, as opposing counsel mentioned, that's a civil, basically, statute. And what happens is the DUI statute says, okay, if you do DUI and you have these other things going on, one of which is you're not giving aid after a crash, you don't give information after a crash where you're DUI and someone dies, there's your enhancement. It doesn't say more than that in the statute. And again, we would look to the plain language. The state would suggest look to the plain language of this statute and what's required. I mean, there are certain strict liability offenses that are out there that are pretty difficult. The one that comes to mind is a statutory rape one, where you can actually be affirmatively misled and endure some serious consequences, even though through no fault of your own technically, but it's a strict liability crime. But I'd like to move on to the first issue if I could, and the trial court clearly did not abuse its discretion in denying the motion to dismiss because, as the court has pointed out, number one, the defendant really did, and I don't know how this gets out of Patterson or how Patterson wasn't even discussed, because Patterson was a case where the defendant didn't even have the opportunity to examine his own vehicle. It was an arson investigation. The state fire marshal came in, the insurance company came in, they did their investigation, they got rid of the vehicle, and the defendant didn't even have a chance to look at it. All the defendant was able to do was hire an expert and say, look at this other guy's pictures, which he did, and he came up with opinions. And in that case, they said, no, there is going to be no dismissal here because at best, just like in this case, more testing could have helped you. And in this case, the state disagrees. There's nothing material exculpatory about the Bentley. If anything, it's got to be people coming in, working on the Bentley, doing testing and things along those lines. And I think I cited two cases, one of which was Lambeau, where they lost the the photo pack. They tried to identify a defendant, and two witnesses says, no, the guy's not in there. Well, the defendant was in there, and under those circumstances, the second TCA said, well, no, that's not materially exculpatory. It's the witness testimony that's important, not just the physical photo pack. And secondly, I believe, as Judge Levine pointed out, there was a whole round. They had 3 experts that came out and examined this Bentley before the first trial. In addition, at the evidentiary hearing, Investigator Snellgrove testified Mr. Serdar could have done any and all testing that he wanted to his heart's desire, and just chose not to. So it's not like...
In the hearings over the motion to dismiss, did Mr. Serdar say what other testing he wanted to do that he could not do?
I know he said he wanted to do computer-guided fault finding, and then Snellgrove wouldn't allow him to do it, but the judge found that testimony to be not credible. So he
No,
found...
but I mean, after the car was found, at the second trial, not what happened at the first trial, but what happened after the reverse, or the... Not
There was testimony about things that couldn't be done because of the missing, and you know, as the prosecutor said below, it was a boneheaded move. It shouldn't have been released, but there was clearly no bad faith in it. And you know, at the end of the day, they've got pictures. They've got Mr. Turek, I believe, had a video of his examination. So they've got not only, I think, let me see, Serdar had at least 50 pictures. Urban took photos in 2010 when he went out. Oh, and by the way, they actually, even though it was in a different condition, they did track down the Bentley and find it. So they got to go out and do even more testing, which, again, plays into the, may or may not have been helpful to the defense. And that's why this is, in my opinion, a Youngblood case and not a Trombetta one, because there is not proof that this Bentley was materially exculpatory. And even if it was materially exculpatory, there was more than sufficient evidence presented, not only through the first trial, but through discovery, that he could have used much better than what happened in Patterson, which the Florida Supreme Court said, well, in Patterson, the burned up truck was at most, you know.
Is the only remedy in Trombetta dismissal of the charges when something materially exculpatory is lost?
I don't know. I know that I don't think that's the only remedy, Your Honor. In fact, there was the old case, I think from this court, Lancaster, that was recently overruled by the Florida Supreme Court in Patterson, where I believe they tried excluding the state from presenting some evidence, and the Florida Supreme Court disagreed with that.
At this trial, were they able to present the evidence through their expert that the brakes didn't work?
They couldn't present that evidence because there's no evidence of that to present. They did not test the actual physical brakes. They've downloaded all the codes, and the argument was that somehow, because of these codes that Serdar and everyone else downloaded from the Bentley, you know, before it went away, is that it somehow surged out of control. And Mr. Serdar's testimony, of course, before the Bentley disappeared was, no, as soon as you step on the brake, that disengages the throttle, so it's not going to go forward. And, of course, that's what Mr. Goodman testified to, or at least told 911. No, I stopped at the stop sign, I didn't see anything, and I didn't see the car that I hit. So this whole surging out of control thing, obviously, is an after-the-fact trying to put forth a defense that does not comply with, you know, the evidence that was ascertained on the night of the incident and at the crash scene. Now, going on to issue number 4, the blood draw. At 2:30, as opposing counsel indicated, that's when, or approximately 2:30, that's when we know someone's dead. Well, at that time, we still don't know what happened in the accident. We don't know how he died. We did not know who was at fault for that crash at that point. That's why Snellgrove had to come out, and so Snellgrove had to walk the scene, even though some of the other officers said, okay, yeah, he smelled of alcohol, there were indicia of, well, we don't know if he was the one who caused the accident. That's why we needed Snellgrove to come out. He did his preliminary analysis, and then he went to the hospital and met with Mr. Goodman. And at that point, he saw the indicia of impairment. It was what I think Judge Taylor said, 3 hours already past the crash, and it was going to take, according to his testimony, another 2.5 hours to get a search warrant in the middle of the night. And he did testify that you could not fax or get these by electronic means, at least at this point in time back in 2010. And he had a concern of it being 6:30 in the morning when the crash occurred at 1, and the retrograde extrapolation argument falls on its face, because what if we finally get the warrant, we get the blood drawn, it's 0? How are you going to retrograde extrapolate from 0 if all the blood's dissipated
Well,
from his blood?
he wasn't thinking about all that.
Oh, no, and I agree.
Is it okay in the Fourth Amendment for him to have not even thought about getting a warrant because he didn't know that he had to, I guess, in this case. He thought he didn't have to get a warrant. Is that sufficient to, can you justify it on exigent circumstances when there is no testimony from the investigator that he thought he was under any kind of deadline or anything to get this information?
Well, I think it could be justified under exigent circumstances, but to me, the real argument is the good faith exception, which is, at the time, 316-1933 provided for a forced blood draw exactly in these circumstances. And as a matter of fact, the Lyles case from last year, and I believe it was the 5th DCA, came out with saying, hey, there were no exigent circumstances here, but at this time, Florida law provided for a forced blood draw in a crash involving death or serious bodily injury, so the good faith exception applies. And
Well, let me ask you this. Is the officer's subjective belief that a warrant was not required really controlling, or is, as the Tennessee v. Cates opinion stated, the inquiry is whether the circumstances give rise to an objectively reasonable belief that there was a compelling need to act in insufficient time to obtain a warrant?
I think it probably is the objective standard, Your Honor, not just the subjective, but I would also point out 2 of the cases that I supplemented with. Palazzotto and Sarago, contrary to what opposing counsel argued here today, one of which is from 2008, one of which is 2004. Palazzotto stated, Section 316-1933-1A allows forced blood draws on crashes with serious bodily injury when a police officer has probable cause to believe the driver was under the influence of alcohol. I don't know how a police officer with an appellate court decision saying that you're allowed to do this is going to go back and say, oh no, a staff analysis somehow in 2002 says you can't. And the 2004 case, Sarago, which was the trial court suppressed the blood test results because they thought they were taken under 1932-1C.
If the determination here is that objective, as you concede, then the question is, does it become whether sort of this per se rule that Palm Beach County's too large, it's middle of the night, I am by myself, as opposed to an individual analysis of the totality of circumstances in this case? In other words, it appears that the argument would be that just by the nature, we're always going to have exigency, and that can't be the rule of the Fourth Amendment.
I would agree with that, Your Honor. However, we do have, for example, the testimony the defense put on at the hearing was, hey, you've got a DUI saturation event, and you've got everything in line. I could see when you've got, the judge online, the prosecutor online, you've got everything pretty much pre-printed, everything is going the way that you need to for this, but this was, not something that was pre-planned. This isn't something where you were able to, at least Snellgrove testified to, and the judge found his testimony credible, that he could have, it would have taken 2.5 hours.
I just want to go back to one thing on Trombetta, because it sort of bothers me in the sense that if you have a situation where you have a new trial, well, the prosecutor released this before mandate was issued. So before mandate's issued, it's as if it's the first trial. A new trial is granted. Why should the defense be in any worse position than had this been released before the first trial? So the point is that this seems more akin to Trombetta than Youngblood, because the fact is they're starting afresh. It's a new, that defendant's day in court. Mm-hmm. The fact that they may have had some testing before doesn't mean, or to prevent the technology could change, or they may have, or as a result of what happened with the state getting their own expert, that may open up new avenues. It's their defense. So I don't see how you could say this is not Trombetta.
I could, well, the judge made a finding, and I would point to electronic record 50 or 8156.
Well, I understand, but we look at it de novo, so. I mean,
right, but the issue is, Judge, if, like we had in Patterson, defendant had no shot at looking at the vehicle, and that ended up passing constitutional muster. We've got a situation where this defendant not only extensively had the opportunity to examine, and there's pictures, and there's video, and there's all kinds of stuff that I think satisfies Trombetta, because he has everything else available through other reasonable means. However, there was an order from the court that says, you guys want to come out and look at the car, just let me know, and we'll make it so. And they willingly chose not to do that before the end of the first trial. So I don't think they're in the same situation as the second time around, because they have had more than one crack at it, and that's how I think it would be different from
Does the record
Breda.
show why it was released before mandate was issued in the first trial?
Well, it was actually released before sentencing was. Yeah, because the insurance company wanted their property, and apparently the prosecutor had procedures. Hey, you know, she definitely didn't think there was any materially exculpatory evidence or any evidentiary value whatsoever of the cars, and released them to their rightful owners, who were apparently giving the police a hard time. That's what the record reflects as to why it was released.
Was defense counsel contacted before that release?
The defense counsel was not contacted before the vehicles were released.
But the court really never got to the point of determining whether there was any bad faith on the part of the state in releasing the Bentley.
Well, I thought the judge did determine that there was no bad faith, and it's definitely borne out by the testimony of not only Snellgrove, but Prosecutor Roberts as well. Let's see, we got one, two.
I have one question
Okay.
that's kind of unrelated, but it's like, okay, what do we do now? And I want both of your opinions, because I forgot to ask Ms. Goodernest this. The blood draw issue is on appeal of the Supreme Court. That's also an issue in this case. If we were to affirm this case across the board, I guess we could just kind of hold it in abeyance until the Supreme Court rules, but that could be, you know, the Supreme Court could be a long time. If we reverse this case, that would start the clicking of the 90 days that you would have to retry if we were reversing for a retrial. I'm trying to figure out what it was, what do we do with this when it's sitting there, and do we do anything, or we just forget that it's up there?
I could see two ways of going, one of which Your Honor said, which is holding it in abeyance, and the other is, now, is in this hypothetical that you're reversing?
Yes,
or
no, it's not.
I would rather you affirm, and
No,
if you
I
affirm, then
understand.
have it jollied up to the Florida Supreme Court, I guess, on that issue. Those would be the two
Oh, you mean do
ways
the
I
same
would
thing with
say.
this, is certify this issue up in this case?
Or,
We've already
no,
done that.
it could jolly up because it's still on review with the Florida Supreme Court, because that's an issue in this case. They're going to get a basically free ticket up there if we follow this court's order on that issue.
Okay.
Okay? Double jeopardy. Let me try to get in what I can in 3 and 40 seconds. I would point I supplemented authority with claps from the second DCA, and there's a statement in there that the double jeopardy emphasis is, quote, on adjudications of guilt and sentences, not on verdicts. While the latter may be a condition precedent to an adjudication of guilt and sentence, by itself, a verdict imposes no punishment. And in this case, it just does not make sense that all of this work put in by the jury, that you would force it to be undermined just because there's an appeal in this case. Now, the Macias case cites two different cases, which were Buford and Graves, but I would point out every one of these cases are a situation where the judge either withheld or adjudicated or sentenced or, did something, as Judge Warner suggested earlier, just sentence on both of them and deal with them on direct appeal. I don't think that the argument the defendant's making in this case is that jury verdict equals conviction, and I don't think that that's necessarily borne out by the law, nor does it make a whole lot of sense. I don't know why, because these aren't a situation where you have one crime and a lesser included or overlapping crimes. You have two separate and distinct crimes, and the only thing that ends up being a problem at the end of the day, running afoul of double jeopardy, is we only have one death. And I think that's what makes it a little bit different from most of the other cases that are cited and addressed. And there's no judicial action in this case, just holding it in abeyance to see what happens. So the state would say that the trial court was correct in holding it in abeyance until I get some direction from this court.
Okay,
And if the court doesn't have any further questions, the state would request you affirm. Thank you.
thank you.
In answer to your question of why was the Bentley released, the Officer Snellgrove and other officers tried to float the idea that they were getting undue pressure from the insurance company to get their property returned. And the court found, and they had this whole spoofing calls thing, and the defense proved that that wasn't true. The Bentley Chubbs did not call more than once or twice, and the court found that absolutely that was not true. And that was a waste of time. So they put forward a bogus reason as to why they released the Bentley. They released the Bentley because Roberts was retiring. You can see that through her testimony. She's got 3 really serious issues on that first direct appeal. There was no mandate in that case. During a period of relinquishment, Judge Colbath granted a new trial because of this juror misconduct. But she was in a hurry. It really clearly comes through that hearing as to why she wasn't thinking, but for her to say, that wasn't exculpatory to the defendant, Sadar was wrong. Well, if Sadar was wrong, it was so clear. Why did you have to hurry up real quick, get an undisclosed expert in the middle of trial, prejudicing the defendant's trial preparation, come up with this new expert, and it totally skewed the case. That was an issue on appeal, but this was a discovery
That didn't
violation.
happen in the second trial. Livermore didn't testify.
No, but I'm
Did
saying.
they present even the total theory that they had with the Bentley on the second trial?
I'm sorry.
Did they present that theory on the second trial?
Sadar did testify at the
Sadar
second trial.
testified, and what did he say was the mechanical defect with the car?
He says the mechanical defect of the car is that there's 2 throttle bodies, and they were out of balance. They were out of sync. They were out of specification, and this would have caused a deceleration problem. He never called it a sudden acceleration problem. A deceleration problem and a drivability problem that would not be able to stop as normal.
Okay.
And
So then what did the state present in the second trial to counter that?
the state presented an expert named Stopchinski,
Yeah.
who said that the damage to the throttle body happened during the accident, and then there was a whole dispute about whether the damage to the housing of the throttle body would have penetrated the throttle, and Sadar said, no, this isn't a penetrating damage to the throttle body, and that this was all internal, and this was all a computer-driven
So
damage.
he's saying I'm right because the computer codes show what happened, and the other side saying we somehow did a physical inspection
No, he was talking about the physical inspection too, of the throttle body in Texas where they relocated the crashed car.
Okay, so they're both talking about the same thing.
They're both talking about the same thing. But I would just wanted to say really quickly, if I could, about Patterson, that, you know, the point of Patterson is that they hadn't tested the car before it was destroyed. They didn't know what it would yield. In this case, they had tested the car, they'd looked at the car, they'd presented the physical car to the jury, and it was helpful to the defendant, and it should not have been released as it was before the defendant was even sentenced. As to the thing about holding this case in abeyance, if Mr. Goodman is in prison, he has not been able to get out on bond pending appeal, even though this is his first felony conviction. And if you were going to reverse, particularly like on the search and seizure issue, on the blood draw, there's really no problem with reversing it and sending it back for a new trial. At that point, he would be entitled to bond, and he could get out on bond, and they could certainly stay speedy trial pending the outcome in the Supreme Court of Florida. If you're going to affirm on everything else, there's really no reason why you can't hold it until you hear from the Supreme Court on that issue, because the state has agreed that that issue is binding, and how the Supreme Court rules is binding on this, and it would require a reversal in this case if they rule that these rules are inadequate on the FDLE blood selection collection rules. And I have other things I want to say, but I think my time is up.
Well, let me ask you this if we were, okay, we reverse anyway, and we say in the opinion that this issue's pending in the court, that so we're not
Right.
dealing with that. But if we affirm, do we say, I mean,
Well, I don't think you should affirm, because if you affirm, by the way, did I make myself clear? I don't think you should affirm on that ground either, because, you know, there is provision in the case law that when an issue is pending, then you file a motion to withhold the mandate pending the decision up there, and then you get a
okay,
chance
so
to reconsider it.
we could say is we affirm on all the issues, we recognize this one is pending, we're going to affirm based upon this, we recognize this is pending, and then you would file a motion to hold the mandate.
Yes, but why would you have those extra steps in there? Why don't you just hold on to it? If you're going to affirm on everything.
Because the Supreme Court could take 2 years to do this one. Who knows?
Okay, I mean, I'm just saying that it would be
Is it
better if you
scheduled- actually,
reverse
is it
and then he gets
scheduled-
out
you
on
should-
bond.
you should- Is it scheduled for oral argument yet?
Not yet. No oral, but the reply brief has been filed.
Okay.
And, no, is soon to be filed.
Soon to be filed. Oh, well.
But the FDLE did file their answer brief.
Yeah.
The reply brief is pending, and I would just say that you ask, isn't there some other remedy on Trombetta we can give besides a dismissal? We ask in the trial court for other remedies. Bennett suggests in a footnote there should be other remedies, and certainly Lancaster does. But after the Patterson case, that's not a viable option. Patterson makes it clear. No, the only remedy is if you know it's exculpatory, it's helpful to the defendant, and you don't observe your obligation to hold on to its state, then you get a reversal, a dismissal. Thank you.
Thank you. Thank you both. Court is adjourned.